I'm very happy to moderate this closing session on interoperability, on convergence of data protection rules globally, and we're going to pay specific attention to the rather thorny landscape of cross-border data transfers. To kickstart this discussion, I'm delighted to introduce to the stage Mrs. Elena Mozova, who is Deputy Director General at the European Commission's DG Justice, for a keynote address. Welcome, thank you for being here.
Also, thank you very much for having me in front of such a distinguished panel to deliver some opening remarks. Of course, it is really a landmark event in Brussels, and special also from the perspective that we are still in rather early days of this current European Commission. And from this perspective, it is, I would say, good to eventually look back a little bit, but also look at, in terms of the achievements, but also to look forward, building on what we have achieved in the past period. Now, today I understand that your discussions, they've been fulfilled by insightful expertise and also high-level speakers. Also my own Commissioner McGrath on privacy in various EU policy contexts such as innovation, security, law enforcement, artificial intelligence governance, but also competition in digital market. But EU does not exist in isolation. And our policies have a very strong international dimension, and our goal is to build the bridges for cooperation and then also data flows across the borders and across regulatory frameworks. And over the past years, we have been working with an increasing number of the countries and also international or regional organizations in precisely developing the new forms of engagement and collaboration. And I will just mention a few examples among many others. So one recent development are the mutual adequacy arrangements, like the one we have concluded with Japan a few years ago, and ones we are currently negotiating with Brazil, Korea, and Kenya. Or another example, early this month, we have published the first ever draft adequacy funding for an international organization. And here I'm speaking about the European Patent Organization. And with this work, we have opened a completely new work stream on international organizations. And we contribute to the work of innovators across the continent, but also globally, as they rely on the patents to bring new ideas and services to the market and eventually to boost the competitiveness. Now, another new form of collaboration are the bridges that we are developing between sets of the model contractual clauses adopted in different regions. And we did it, for example, already for ASEAN, and soon we hope that we will proceed also with Latin American countries. And this bridging approach facilitates transfers with many other jurisdictions around the world that have similar contractual mechanisms in place, and therefore helps companies, and particularly the small and medium companies, to navigate sometimes very difficult to understand regulatory requirements in various markets that they are seeking the access to, and also business. Now, G7 has recently noted that model contractual clauses are one of the most used tools for data transfers globally. And by working together with other jurisdictions, we are making an important contribution to making transfer mechanism even more interoperable globally. And these types of innovative bridging solutions are particularly well suited to the reality of digital economy, because data often flow to multiple destinations, but also simultaneously, consecutively, and sometimes back and also forth. And as a world's largest importer, but also exporter of digital services, the EU, with the 27 member states, has a keen interest in further developing this approach and make it a part of our big strategic approaches to the European Union's adequacy decisions. Now, studies have shown that European Union adequacy decisions boost digital trade by 6 to 14%. 6 to 14% by creating and benefiting from complementarities with the trade agreements. And to boost these synergies, countries with EU free trade and digital trade agreements are in a way prioritized for adequacy negotiations, amplifying these trade benefits. And this has been already achieved with Japan and Korea. We hope to achieve it very soon with Brazil, and also with the largest, from this perspective, with the largest economy in Latin America. And the future mutual EU-Brazil adequacy decision could significantly boost the trade flows, complementing the European Union Mercosur agreement, on which the political agreement was reached at the end of the last year. Now, building the bridges, and again back to that, is also why last year we launched an adequacy network. Adequacy network bringing together all the 15 jurisdictions that currently already benefit from an adequacy decision. Research has also found a network effect in terms of growing digital exports for all adequacy receiving countries who benefit indirectly from the EU adequacy decision, so mainly as a result from the EU-US data privacy framework. And our goal is therefore to continue connecting different transfer mechanisms and in a way develop a multiplier effect in terms of safe data flows and also in terms of the trade benefits, because they are interconnected. And I also very much believe in the potential of regional networks of data protection authorities to join forces and foster convergence through concrete but also very pragmatic cooperation on guidance documents, common compliance tools and enforcement cooperation. And this is why I very much welcome the first meeting in Morocco in September last year between the European Data Protection Board, the African Network of Data Protection Authorities, and the Ibero-American Network. And I hope that additional regional networks and organizations will join at the next meeting very soon. Now, all these different initiatives have led us to work at the European Commission on privacy and data flows, which many more countries and organizations than the past, which is an extremely positive and encouraging development. And of course, under this new Commission mandate, more can be done and will be done as we intend to continue our bridge building attitude. But one thing that is clear, individuals and their rights should remain always in the center of our approach to data flows. Formal check the box, non-right-based transfers tools do not longer work. They deliver neither the protection of the individuals are entitled to, nor the predictability and legal certainty businesses so rightly also expect. And in contrast, the European Union efforts over the past years and our vision for the future are about ensuring that the protection travels with the data as captured in the initiatives such as data free flow with the trust as developed at the initiative of Japan this time in the context of G7 and G20. The need for the bridges is greater than ever, but geopolitically, both geopolitically, but also from the governance and the regulatory point of view. Because data protection is a key foundation of the expanding digital regulatory framework, whether it is about artificial intelligence, for a competition on digital markets, access to and sharing of public sector data, or consumer right, you name it. And this also means that more frequently, the different authorities within their own regulatory framework and under their own balancing act between various rights will handle data or privacy-related matters. And privacy will and should remain central, but data protection authorities will find themselves also increasingly part of this broader decision-making processes. So the future will therefore require much more interplay, much more interaction and interconnection. In other words, again, more bridges. And this puts a significant responsibility on the data protection authorities to ensure that privacy rights continue to be effectively protected in this increasingly diversified regulatory landscape, and that data protection rules are interpreted and enforced, in a very consistent manner under those different legal regimes. And this requires, again, innovative thinking, multidisciplinary solutions, and cooperation between the data protection authorities and other regulatory authorities. So in the European Union in the next years, the implementation of the different digital acts that we recently adopted on top of the DSA will also include, for example, work on interplay between the GDPR and the Digital Market Act or the Artificial Intelligence Act. But of course, these challenges, which can also be opportunities, are not limited to one region. And as announced last year in the second report on application of the GDPR, the Commission will therefore seek a mandate from the European Union member states to negotiate enforcement cooperation and mutual assistance agreements with non-European Union countries. Now, to conclude, it is a time for privacy enforcers to be equipped with the tools, like those that exist for the cooperation in other regulatory frameworks. And like, for example, competition, product safety, or financial supervision. Because effective enforcement is an important part of the trust in the data flows. And you can count, of course, on the Commission to continue to build the bridges for cooperation across the borders. So many thanks for your invitation. I hope I fulfill my mandate to give some program results for the benefit of the next panel. And I'm myself looking forward also to learn about your conclusions. Thank you very much.
Thank you so much. Thank you very much, Mrs. Musova, for this highly insightful overview of what the European Commission is working on. Much appreciated. Thank you for joining us. And I especially loved just highlighting and bringing back to the fore just how fundamental cross-border data flows are to the functioning of the whole digital ecosystem, essentially. So we'd love to dive into all of this and more with a very excellent panel that I have with me here today. And I'd like to introduce Monika Tomczak-Rodnikowska, Group Head of Privacy, Digital and Regulatory at Process Group, Matko Moragon, Senior Public Policy Manager at Workday, and Chris Taylor, Director of Regulatory Strategy International at the Information Commissioner's Office, the ICO. So thank you so much for being here. We don't have a super huge amount of time, so we'll do a kind of a quick 2 rounds of questions just within the panel, and then we'll open the floor for questions. So when the time does come, please don't be shy and ask your questions. So to dive straight in, we've heard a bit from the European Commission and the sort of European perspective on the planning and priorities on cross-border data transfers. And it would be great just to kind of continue on that and get a regulatory perspective from national level, kind of the landscape. So I would turn to you, Chris. Could you tell us a bit about where you think we are now in terms of ongoing work towards achieving interoperability, convergence of cross-border data transfer rules?
Certainly, and thanks, Bianca. Thanks for involving the ICO in the event today, and it's good to see so many people are making it to the end of the conference. Truly, we've identified the most committed data protection enthusiasts by those who are here to the end, so thank you. On transfers as well, truly exciting and thrilling topic. So we at the ICO take a very pragmatic and risk-based approach to a lot of our work, and that's true also very much about international data transfers. So you asked where do we see things at the moment. I won't go into it, but obviously we have some challenging geopolitical headwinds at the moment when it comes to truly free flow of data globally. But I think we do, from our perspective as a national regulator, we do see good incremental progress being made. We heard some really encouraging comments from our colleague at the Commission just then, and we do see progress being made across a wide range of international fora who are all thinking and considering around the same issues in association with global data flows. So whilst there's no kind of magic bullet on the horizon to resolve the safe free flow of data, I did just want to highlight maybe some of those practical and incremental developments that we've been seeing that people may be aware of or may not be. So at the back end of last year, in the autumn, the Global Privacy Assembly that many of you I know will be familiar with. Those of you who aren't, it is the membership body for data protection authorities globally. Now has over 130 members from every corner of the world. And in the autumn, they adopted unanimously a resolution on data free flows with trust, looking to identify the key essential elements that would constitute safe, what would need to be seen to constitute safe free flow of data. Now that was work undertaken by colleagues at the German Federal DPA and at the European Data Protection Supervisor. And actually it's a really strong piece of work that identifies familiar concepts that we will find in many legal and regulatory frameworks of transfers, but it really sets out a set of agreed principles between regulators as to what constitutes safe free flow of data. Now that's not a binding document, it is a policy document, a discussion document, but I think we hope that it will continue to provide a basis for proactive, productive conversations around convergence and interoperability in the future. Also published by GPA recently was a really great piece of comparison work undertaken by our colleagues at CNIL, looking to compare different contractual clauses from different contractual clause regimes right across the world, from ASEAN through to Council of Europe model clauses, through to GDPR clauses. And we're really interested in seeing on what could be built on that work next. People will also be familiar with the development of the model contractual clauses from the Council of Europe themselves. And we also have work going on, again, very closely aligned with our colleagues in Germany through the G7 DFFT roundtable, where we'll be thinking about how we can build on all these initiatives and to take the next kind of practical steps in trying to operationalise data free flows with trust. And the concept of bridging comes up a lot. I think we heard it from Irina, and we'll be definitely thinking about the work that might need to be done to bridge between different contractual clause regimes over the coming months. And then just finally what I'll say is there are of course limits to what regulators can do in this space. And government actions will be as important over the next year or so, particularly when we think about some of the changes that are happening around trade, around growth, and in relation to security as well. So I think we'll be watching that space very, very closely indeed to see how that may affect the broader picture for transfers. And then, absolutely finally, I promise, we are also really interested in what might more be able to be achieved between countries with recognised high standards of data protection. So in particular between countries in receipt of an adequacy decision from the EU. So we very much welcome the Commission's initiative where they set up a roundtable on data flows between adequate countries. There's a great new initiative from the EDPB as well, who've been inviting more cooperation with adequate country DPAs. And we ourselves at the ICO have an informal network of adequate country DPAs to try and think about how we can build greater trust between us all, hopefully in the intention that it will build greater trust to enable better conversations around data flows and data transfers.
That's wonderful. Thank you, Chris, for this interesting overview. It sounds like quite some work has already been done, but that so much of it is also still in progress, particularly in the context of the international fora that you mentioned, that we can go back to in a little bit. But for now, I think it would be also really useful to dive a bit into the practical side. And Monica, your role at Process is very much global in scope. And I'm curious to hear what are some of the kind of key challenges and considerations that you're seeing in the data transfer landscape in practice, kind of both in Europe but also internationally.
Thanks, Bianca, and thanks for having me. And I'm really pleased how our panel is turning out. Speaking about international transfers on the last slot, it's doom and gloom, and we all kind of will leave the room in despair. But we've just heard a very optimistic messaging from Mrs. Morozova and also from you, Chris, in terms of the sort of nascent understanding that despite those big geopolitical tensions, there's still so much work that can be done to facilitate transfers, to build trust on a sort of global basis, and maybe building and bringing the international transfers dialogue be sort of on top of the sort of discussion that is happening in the transatlantic context. So from a practical perspective, what we see being a global tech investor with presence in LATAM, India, Asia, Europe, you name it, the US. What we really see is that the fact that those efforts actually are sort of perceived and appreciated on the ground with practical implications in terms of countries such as Brazil that have adopted the standard contractual clauses, but also being sort of open to discussing the equivalence and the sort of understanding that this is not about wordsmithing, it's more about what we're trying to achieve in terms of the objectives of ensuring international data transfers. We've seen this in South Africa, we've seen this in Asia as well. And I think in this context, the work of the European Commission, the work of the ICO, and the work of the Global Privacy Assembly can bring tangible effect to businesses in countries like India, where the data localization sort of ideas are still floating in the air, and just show that those alternative models of building bridging and interoperability on a global basis actually work much better, and there are ways to address those concerns that many of the countries have in terms of national sovereignty, the third way of international data transfers policy, that they can actually exist in this sort of more interoperable environment. So indeed, the challenges remain, and there's still a lot of fragmentation and a lot of complexity that companies worldwide need to deal with. But we also see really signs of optimism by more of the ability to have access to simpler, more usable instruments, and also the willingness of different stakeholders in countries globally to look at it from that interoperability lens.
That's excellent, really interesting to get a bit more of the global perspective, and let's see if we can kind of keep this positive vibe going. So Marco, we've heard a lot about trust today. It's been like trust. So let's bring that also to the cross-border data flows discussion as well. How do you think that we can have more confidence, more trust bolstered in cross-border data flow mechanisms, particularly amidst some of the geopolitical tensions that we're seeing at the moment, and the kind of shifting regulatory landscape? How are you seeing that right now?
Yeah, thanks, Bianca, and good afternoon, everyone. Thanks for being here with us. It's great to see there's a lot of alignment already, but that's not to say there isn't any kind of controversy or geopolitics, right? So yeah, definitely happy to touch on that. But first, I wanted to give a little bit more detail on kind of why data flows matter. We often, hear data flows matter, but we don't always hear about why and how. So just want to give a bit of specifics on that. So for global companies like Workday and for Europe's economy, trusted data flows are essential. The cloud-based HR and finance solutions that we provide rely on secure data transfers to enable our customers, which include over 2,000 European headquartered companies, to manage their global workforce. So this gives them access to real-time analytics, payroll or talent management information, and it boosts their productivity and their competitiveness. Also wanted to highlight some of the work between the OECD and the WTO looking into data flows and the impacts, right? So they suggest that if all countries were to restrict their data flows, global GDP would fall by 5%. They also say, the OECD also says that data localization measures can raise data management costs by 15 to 55%, leading to higher prices for downstream users and reduced resilience. So it's clear that disruptions to data flows can significantly impact European GDP and hinder its growth and innovation. We're also all aware of the rising geopolitical tensions, which unfortunately is affecting trust in data flows. And so, while the EU-US data privacy framework remains in effect, we're closely watching the US administration's actions. We're also seeing how these tensions are coming over to the European Union, and there's more growing calls for data localization. So these tensions, unfortunately, increase legal uncertainty for organizations that rely on cross-border data flows, especially for smaller organizations that are the bedrock of Europe's economy. While the timeline for easing tensions is uncertain, we definitely can prepare ourselves by taking some proactive steps, and I'll just mention a couple now. The first action is for governments to continue their vital work on trusted data flows through initiatives like the OECD's Data Free Flow with Trust program, the Global CVPR Forum, or roundtables of the G7 DPAs that have just been mentioned. These aren't just talking shops, but they are vital platforms to develop and to harmonize global standards. Governments must resist the temptation to retreat into isolationism and abandon these collaborative efforts. This is particularly critical for Europe, which stands to gain immensely from leveraging its data as a strategic resource for growth, competitiveness, and for innovation. However, we of course shouldn't forget that this value must be achieved while upholding fundamental rights and values, including those enshrined in the GDPR. We can't exchange one for the other. So the second action that we want to identify falls on the organizations themselves, right? It's not only about the government, it's also about the organizations doing their part. We believe that privacy is a fundamental right, and multiple studies show that organizations that invest in privacy reap substantial benefits, including increased customer trust and brand recognition, reduced risks and costs from data breaches, and also better data management and governance, which then can help them prepare for other laws like the AI Act. So more specifically though, on the data flow side, organizations can consider a thorough review and, if needed, an update to their transfer impact assessments to ensure full compliance and to build that trust. We must also actively look at and consider the transfer tools available under the GDPR. If organizations only have one and they see that there are headwinds, they see there's greater risks, maybe they should look at additional tools that can solidify that trust, right? But beyond the mere compliance portion, we need to engage again in that open and constructive dialogue with authorities, fostering that collaborative environment that we need with practical solutions. Of course, all of this work isn't easy. It takes a lot of time, it takes a lot of effort. So that's why organizations need help from authorities to make sure that the rules that they adopt and guidelines that they publish are clear, they're consistent, and they're accessible to organizations of all sizes and sectors, especially SMEs. Often we'll receive documents that are, many pages long and it's really a challenge to understand. And ultimately they say, let's just hand it to legal because that's too complicated for us, right? And so, we want to avoid that. We want to make sure that those materials and those deliverables are accessible. Finally, to really solidify trust in data flows, obviously we need to prioritize transparency and security. Organizations can lead the way by championing data explainability, moving beyond simply stating what data is collected, but also plainly say why it's needed and how it's being used. Demystifying these practices, we think, will strengthen confidence and trust. We should also be transparent in how we respond to legitimate law enforcement requests for data. Workday, for example, has a policy of transparency in this area, and I can say that to date, we haven't received any valid data access requests from law enforcement worldwide. Equally important is cultivating a culture of security by default. So this also includes robust security practices that should be included at every stage of data handling, from collection to deletion. Also things of strong encryption, multi-factor authentication, regular security audits. But for those of you that aren't too deep into the cybersecurity side of things, organizations like ENISA and national cybersecurity authorities have lots of resources, lots of guidance, and they're there to help us and identify some best-in-class resources that we can adopt. So those are just a couple of ideas, but I'll stop.
Yeah, no, thank you, Marco, also for mentioning some of those practical principles like transparency, also data security, accountability, and so on. I think that's really interesting. And just what's also been mentioned a lot is data free flow with trust, global CBPR forum, and I'd love to just dive into those a little bit more, Chris. What do these processes look like in practice, and what do you think is really needed to operationalize them, and the principles that these frameworks really are based on?
Sure. So I'll focus on CBPRs, I think, at this point. The DFFT side of things, I think I spoke about briefly before. So I don't work for or am representative of the CBPR system, but in the UK we are very interested and engaged kind of observers and watchers of how the CBPR system is developing. Our government is an associate member of the CBPR forum, and we as the national regulator are part of the enforcement cooperation network that sort of sits alongside the CBPR forum, known as the Global Cape, which we didn't just join because of the Cape metaphor, but we quite like that. We've been watching it with interest for some time. For those of you who aren't familiar with the CBPR system, it is essentially a certification system that has developed out of the Asia-Pacific region and has had renewed global interest following the US's championing of it and turning it into a more globalized potential system. It isn't just an inverted commas a transfers mechanism, but it's also a certification system for your company to get certified to the standards that are within the requirements for CBPRs. And it's been a really interesting thing to observe over the last year or two as it's been globalising, the extent of openness with which the development of that system has been undertaken. There's been quite a lot of reform of it just within the last year or so, addressing some of the areas where there are differences in standards or differences in application. And I think we can see it being potentially a really quite important year for the CBPR mechanism. I think if it's not open to industry to sign up now, it will be very imminently, and seeing what the level of business demand for a system like that actually is in practice, I think will obviously be really, really key, particularly in that first year or so of being open. And again, the kind of very broad coalition that the US has brought to having the discussions around the CBPR forum will be really important to see if that continues. So we remain a kind of interested observer to it. We really appreciate actually the degree of open debate that there is within the forum about some of the really challenging issues around transfers, and there's been a real willingness to engage in open and kind of creative dialogue around transfers related issues, which we perhaps don't always see in other areas. So it's interesting as well from that perspective.
Great, thank you for providing a little bit more insight into that. And Monica, I want to come back to you because another theme that, or another issue that has very much come up today has been around SMEs, small and medium-sized enterprises, and kind of seeing how the regulatory framework can be more accessible to these organizations. And also linking to the kind of impetus or the sort of the conversation around more and better innovation. Obviously cross-border data transfers plays a role in that. So how can these solutions be made more accessible for SMEs?
Yeah, thanks, Blanca. I think this is actually really important because I think it has been mentioned by Ms. Morozova that this is at the core of innovation and the ability to thrive for the European businesses to thrive on the global scene. But I want to touch on that question from two angles. First, the angle of the European tech businesses. I think there is a palpable sense of sort of concern in the European tech businesses about the future of some of the instruments because of the geopolitical tensions and potential negative developments in the form of, prohibitions of transfers or, the faith of the transatlantic framework, because this has a true and direct and concrete impact on access to technology. And I think this morning someone already mentioned about the fact that European businesses have been sort of, to some extent, whether for the right reasons or not, prevented access to some of the more advanced, forms of agentic AI, or the launch of certain of the AI models have been delayed, and that has been noted, and therefore that concern that those type of negative developments will impact in a very direct way the competitiveness of the European tech businesses, in particular the small ones, is there. So it will be, of course, a difficult dilemma, because as Marco mentioned, we need to preserve our European values in that bigger picture. But I think if we are talking simplification, getting rid of records of processing activities will not solve the issue of not being able to access technology which is at the edge of moving our companies to the next phase of generative AI-powered e-commerce. So those will be tensions between those type of simplification efforts. We have not heard that any of this is coming, but there is concern, and there are people asking questions, what will come next. In terms of access to those type of more affordable transfer mechanisms, unfortunately, most of European tech companies are not rich enough to get binding corporate rules. This instrument, which is a fantastic transfer instrument and an accountability mechanism, is just not accessible for most of European companies. And there's probably not a sort of magic solution to that. So mechanisms which were more based on certifications, like with the CVPR forum, that are very much observed with interest by our companies outside of Europe, may be an alternative. I don't think we are there yet in terms of those initiatives, but you know, the more we have of the adequacy, the mutual adequacy decisions, more of those data privacy networks that we've just heard about, and leveraging, this is making the life of European tech companies simpler in terms of even assessing and documenting risks related to some of the transfers, some of the access to technology, some of the ability to quantify what will be our sort of risk appetite in strategic directions if we opt for the use of this type of technology that inherently requires, you know, some forms of transfers. Also, I think in this space of international data transfer, sorry to say, but we've seen instances where the risk-based approach was not really prominently featured for, you know, sometimes for good reasons, but it may be the case that in the context of those big strategic dilemmas, we will have to look more at the sort of risk-based approach as a way to differentiate between different sort of risk assessments from a transfer impact assessment perspective, and see, you know, what are the instances where there be more impact on the actual European users versus situations of not so significant impact. So it's a complex kind of, I think, multi-factor current kind of situation for European tech businesses, but definitely it would not be a good thing if in the name of sort of GDPR burden or in the name of international transfer restrictions, European companies would not have access to the latest and greatest, in particular in the space of AI. So that's the European sort of side of things. But when you look also at the global perspective, I agree with Chris that it has been a fantastic year for CVPRs, and it has been perceived as a sort of instrument that can happily coexist with adequacy decisions, and being the, you know, the creating this interoperability for LATAM and Asian regions, being a model for countries where those digital regulatory decisions are being made, like India. We hope that this will be the case, that it will continue, and actually when it opens for, you know, for businesses in this region, it will be embraced and will create that success story, and that drives further adoption, and being a relatively affordable mechanism for organizations that operate across, for example, just across LATAM. So I think we are we try to look at the future with optimism, but we are indeed concerned that the European tech businesses will, you know, maybe the collateral damage of the bigger, you know, bigger tensions. And of course, you know, we understand that the sort of the preservation of European values may be part of that discussion.
And I really like that you mentioned this kind of the possibility for a happy coexistence between you know, the global CVPRs, for example, and EU adequacy. And I wonder, you know, you also mentioned quite a lot access to technology and AI, and I do kind of think about how this complicates the picture. So I would come back to you, Marco. You know, what are some of the challenges in the face of this so-called AI boom, and what do you think can be done to begin to address those?
Yeah, thanks, Bianca. I think the question is, where do we start, right? You know, the global AI race, which is being driven by competing models in the EU, the US, and China, is fundamentally fueled by data. You know, data is the lifeblood of AI. It provides essential information needed to train high-quality AI models. So this inherent reliance on data, which often includes personal data and needs cross-border data flows, links data protection and AI together. And actually, as FPF just recently noted in a blog of theirs, the initial legal challenges in Europe faced by large language models were rooted in data protection law. It surprised a lot of people, perhaps probably not too many people in this room. Nonetheless, I think it underlines the critical role that policymakers and DPAs play for AI governance. But to answer the question, yes, there are some challenges that policymakers and DPAs play for AI governance. The AI boom is creating or amplifying to cooperate on data privacy, and I'll just mention a couple of those. I think the primary challenge goes back, again, to the fragmentation of legal norms, court rulings, different enforcement practices regarding data protection and privacy worldwide. While this diversity reflects different legal and cultural values, it does lead to some conflicts between legal systems and increased burdens for data flows. Just to give some examples, different interpretations of data minimization principles can create compliance challenges for AI developers operating across regions. Another question that we have is on the role that DPAs will play in the context of AI Act enforcement, right? Will they have a central role? Will it be on the sidelines? Will it be consistent across EU countries, or will it be different? The jury is still out, but I think there's a lot of questions at this stage about what's going to happen there. So then how do we move forward, right? So again, I think we go back to the need for international dialogue and collaboration among governments, but also, of course, with industry and civil society to identify some of these common principles, frameworks, and approaches at the intersection of data privacy, data flows, and AI. So we definitely support the efforts by the EDPB, the G7, the OECD, and groups like FPF or CIPL to advance these discussions and to bring the people together. It's great to see the G7 DPA's priorities for this year are 1, international enforcement cooperation, 2, AI, and 3, data-free flow of trust, right? So that's exactly what we're talking about. I think that's spot on, and we hope to see results and a lot of activity on that this year. So I think tied to this, though, is also what you were mentioning before about the need for European leadership globally, right? So we have a lot of examples from data privacy where Europe's been a leader and where it continues to be a leader. So Europe needs to be looking outward. It needs to be looking at shaping global conversations and looking at how to develop AI in a way that's grounded in data protection and trusted data flows. But to do that, Europe needs to be unified. It needs to have a clear plan of action, and it needs to also be an attractive place for organizations to want to develop and deploy AI. So those are it's a lot to ask for. There's a lot of work to be done to make that happen. But we have high hopes for that. The second significant challenge lies in the sheer velocity of AI model development, both here and internationally. This rapid pace is putting a lot of pressure on authorities to simultaneously enable the benefits of AI, but also safeguard fundamental rights, including those of data protection and privacy. Businesses that are developing AI urgently require clear and practical guidance on the intersection between privacy laws and AI. Similarly, enforcement authorities also have the daunting task of ensuring AI models and systems that are entering the market adhere to local data protection and privacy laws, including the GDPR. So, to address these challenges, we do have some ideas or thoughts for both authorities and for AI developers. Again, for authorities, it goes back to working together, both at EU level, but also with like-minded countries with similar privacy laws, like the UK, to address these challenges consistently and to do it quickly. We don't want to see different recommendations and potential conflicts between authorities, even within the EU. So on one hand, we hear that there's lots of appetite and interest to work together and collaborate, but at the same time, when you see some of these documents that are being produced, they're not saying the same thing, right? So I think that is definitely putting us in some challenges of, okay, which one do we look at, right? So I think in addition, or just to give one example, I think something that we're looking forward to is, of course, the EDPB guidance on interplay between AI Act and GDPR. That's something that I know is coming hopefully soon, so we look forward to reading that and to also being able to contribute to it in advance of its publication. Authorities also need to embrace AI tools themselves, right? So AI can accelerate the speed and the accuracy of regulatory work. It can automate manual tasks, and it can deliver real-time insights into the latest technological and legal developments. Given the inherent complexity and legalistic nature of data privacy guidance, we think that AI can be instrumental to make it more clear and accessible, especially to SMEs and to non-legal professionals. I think this has been a big challenge that maybe AI can be a tool to support them with in the future. But when it comes to AI developers, they shouldn't also wait until the laws are all finished or until the additional guidance is coming out, they need to start their work to prepare now, right? Or yesterday if they haven't yet. They should be embedding privacy by design from the outset, incorporating data minimization or anonymization or other privacy-enhancing technologies. They can also integrate automated compliance checks into the AI development pipeline and identify potential privacy violations before they happen. So we think that designing AI systems also that are transparent and that are explainable is also critical for building trust with both users and with regulators. So the AI Act sets a good baseline for that. So just to finish off, the intersection between AI and privacy and data flows, there's a lot going on right now, but nonetheless, we think that we need to keep talking to each other, we need to keep working together, consulting, and finding the right balance to ensure that both fundamental rights and AI innovation are protected together. Thanks.
Great, thank you, Marco. And I really like that fundamental things like privacy by design, data protection by design are still very much part of the discussion, also in the context of cross-border data flows. And I think an open question is when we hear terms like data localization, tech sovereignty, and these things, how can we kind of prevent fragmentation more broadly in this really complex geopolitical landscape? Luckily, it's still March, and much of the year is yet to unfold. So I guess we will see. With this, I think we have just a few minutes for some questions with the audience. Would anybody like to ask a question? Yes, please. There should be a mic. Yeah, there's a mic.
Hi. So I just want to ask about the data privacy framework. So basically, at this point, all independent agencies in the US are being challenged, and I understand this is a key cornerstone, basically, of the data privacy framework to allow free flow of personal data to the US. So I wonder, what do you think? Should the DPF be invalidated?
Oh, that's a big question. I wonder if there are any thoughts in the panel about this framework. How do you see it developing over the course of this year? I think there is no specific answer. It's really still developing, and it's quite uncertain. But,
Well, I can say that from a practical perspective, most organizations in Europe were, slightly skeptical in terms of relying solely on this transfer mechanism. So I feel that if from a sort of practical what happens on the grounds, a lot of organizations have chosen to have a backup option, like Marco mentioned, and rely on various transfer mechanisms. But I agree that what will happen with the transatlantic data framework is sort of more impactful than just the validity of that mechanism, because it's really about the assessment of the state of US affairs. And I think that's probably this is probably the last thing that DigiJust wanted to happen in terms of their simplification appetite and their ability to push for those very commendable initiatives that we've heard about earlier today. So I think we are in the lucky position that we don't have to take the final decision, but I think that that's something that will require a lot of careful balancing and careful assessment from the Commission to see also how that indeed impacts this desire to preserve or even increase European competitiveness.
Yeah, and I agree with what you said about, I think in addition, Workday is an active participant in the EU DPF, and before that, we were also signed up to the Privacy Shield and the Safe Harbor Agreement. If there is an EU-US agreement in place, we will sign up to it, right? But as you said, that can't be the only thing that we sign up to. We also need to look at additional, transfer tools for that. We are hearing some positive messages from the Commissioner McGraw. He was in the US not too long ago when meeting with the FTC Chair Ferguson, who also expressed support for the continuation of the DPF. So we hope that these positive signals will translate into concrete actions, right, to reappointments for some of those immediate actions that just happened. But we don't know, when that's going to happen. So we don't know, is it just going to be something that in the end it will be the courts that will decide? Obviously some of those challenges are still ongoing, right? We're all waiting and see what's going to happen. But I know that both as Workday, but also as some of the U.S. industry associations in the United States are re-emphasizing the importance of this framework, that it be maintained and that it be preserved. So let's see what happens.
Yeah, and it sounds like for now variety is variety of tools seems to kind of be a little bit the answer here. There was one more question here in the front row.
Thank you very much for a very interesting panel, Marianne. I'm Marianne from BOC, the European Consumer Organization, and thank you for that question because I was going to ask about that and also about the mechanism in the UK and what you think about the changes that are ongoing. Of course, we're talking about a bill that it's leading to final stages. So I wanted to ask the panel, the three of you, your thoughts on what should happen because we are quite concerned about some of the changes in the bill right now. Thank you.
Thank you. Chris, would you like to have a go with that?
So I can't talk on behalf of the UK government who are responsible for the bill, and we have a published public statement in terms of our perspectives on it. I think it would be extremely dangerous for me to get into all of the details of the elements of the different changes that there are. I think probably what I would just observe in line with our public statement is that we don't see anything within those changes that give us material concerns at all, or that would be of concern, for example, in considerations around adequacy. There are some changes. There are some changes around things like the way that lawful bases are described in the face of the legislation. There are some more changes around research provisions and in other areas as well. But when we step back and we look at the overall scale of change and what's trying to be achieved, it doesn't give us, as an independent DPA, any concerns about the level of rights and protections in the UK, and indeed we think there are some helpful clarifications within the changes. It's also particularly beneficial to us as an independent authority. It moves us onto a more modern corporate governance approach as regulator, and it also increases some of our powers in particular areas, so it increases our finding powers for PECA. So beyond that, I think I would just direct you to our kind of public statements about the bill. I'm very happy to pick up in conversation with you afterwards as well.
I think from our practical perspective, I think it would be really disastrous if that framework is challenged or put under question mark. I think it's actually a great opportunity to forge closer ties. If the UK is quite important role on the global scene and reinforcing this sort of building a alternative coalition of likely-minded, data protection authorities and likely-minded governmental approach. If we started to challenge that, we kind of introduce even more complexity, both for European businesses, UK business. I think it's really nobody's practical interest. And I think there's definitely room to sort of look at those changes and, just assess them as sort of equivalent, sufficiently equivalent, or not going against the core values of the adequacy determination. I think ultimately, there are differences with the laws of the countries that have received adequacy in the past. They're not identical to GDPR, and we were still able to overcome that. So I would definitely, in terms of how the European Commission will look at it, I think there's definitely room to, for more flexibility. And also the process is not finished yet, so in a sense we may see, but I see this really as an opportunity for closer ties between Europe and the UK right now. I don't know what, maybe Marco may disagree.
No, not at all. I think for us, the number one priority with this bill is that it maintains adequacy with the EU. We don't want to start to see adequate countries taking different approaches and then removing those that trust. Really want to make sure that that's protected. Now, if that can mean small tweaks and improvements in terms of supporting SMEs, that's one thing. But if they're really, and I haven't looked at the latest versions of the bill to understand, really are there other changes that are really going beyond that. that's something we will need to look at. But as you said, the Commission has asked for an extension in terms of their adequacy potentially to December of this year. So it looks like there's still a bit more time, but let's see also how quick the UK is to finish this bill.
Thank you. Yeah, so there's really a lot in the pipeline. I think, though, that's all we have time for today. Thank you so much to my excellent panelists for just engaging so openly with the topic and for sharing your thoughts. And thank you to the audience for sticking it out till the end and for your questions and interaction. So with this, I'd like to close the program and wish everybody a wonderful rest of the evening. Thank you.